Section 2, or panel 2 of our conference today will be devoted to energy disputes arising from transition to green economy and the Energy Charter Treaty reform. We already touched upon the ECT reform during the previous panel, but now we'll have evidence from the Energy Charter Treaty Secretariat itself about the reform process. But we'll also talk about issues which relate to climate justice, social and governmental standards, which is another topic which becomes more and more of practical importance to dispute resolution practitioners. And we are very pleased to have Nicolas Angelet, who is chairing this session today. He's been a loyal member of the Investment Treaty Forum for a while. He's professor of public international law at the Université Libre de Bruxelles, and also a very well-established practitioner working as counsel, as arbitrator on issues of public international law, also on issues of commercial arbitration and investor state arbitration. And Nicolas also mentioned some of other cases he's doing outside of the traditional ISDS realm, which maybe he will mention during his remarks. Nicolas, up to you. Over to you.
Thank you very much. Thank you very much. Thank you, Jarek, for your kind introduction. I'm very happy to chair this distinguished panel on energy disputes resulting from transition to green economy and the Energy Charter Treaty reform. Now, we've discussed transition already. Professor Butler told us a number of very important points. We've discussed it again with Ms. Miron. And perhaps we should now revert to a number of salient issues regarding transition to the green economy from a legal perspective. Why is transition a legal issue for us? Well, I think first, obviously, what prompts the transition is the environmental crisis. The ecological crisis, which in turn generates human rights problems. And therefore, I think the first aspect of transition is that it triggers issues of regime conflicts between international investment law, human rights law, environmental law. It is not that international investment law has always been agnostic of environmental or social issues, but these issues come to the forefront, they become more significant. New environmental and other norms are developed. And so this is the first aspect, conflict issues, regime conflicts, which we will discuss. The second one was mentioned by Professor Butler, is concerned with what we are going to leave behind us in the transition, which is the fossil fuel industry, which obviously has generated enormous amounts of investment and therefore is about to generate issues of lost assets, stranded assets, which triggers a question of to know who will pay for the assets that are being left behind. The third aspect, which was also highlighted by Professor Butler, is what we are moving to, the green economy. You will have seen the slide of Professor Butler on the carrots. I think we might consider having one more event, Jarek, on carrots in international investment law, incentives. I think it is a feature of the green economy that it is highly regulated, therefore raises a lot of issues of the relationship between the exercise of regulatory powers and international investment protection. This is an issue we know, but which is very important, which will be increasingly important. And obviously, it is a new field for us from a technological viewpoint, also from a legal viewpoint, and therefore this comes with childhood diseases something that the Kingdom of Spain has acutely experienced. So I think that is the third aspect of transition and investment law. And the fourth one is transition itself. Transitional law, I don't know if the expression exists, but the law governing transition from one legal regime to another is a legal discipline in itself, with a lot of difficult problems, risks for operators, for lawyers as well. I remember participating, Jarek, in another conference probably 2 years ago, or 3 or 4 years probably, on successive investment protection regimes. And I remember mentioning what I coined the London Tube principle: mind the gap. And so these are the issues we are now going to discuss with my brilliant panel. First, we have Lucia Pisikova, who is an associate with DLA Piper here in London, and she will, I think, mainly concentrate on the regime conflicts as we experience them now. Then we will have Alejandro Carvalho Leda, who everybody knows as the legal counsel of the Energy Charter Secretariat. And Alejandro will resuscitate the Energy Charter Treaty reform, which was prematurely buried by Matthew Weiniger earlier today. So then we will discuss how the reform seeks to adapt to these conflicts between regimes. And then we will have Jacob Ragwald from Mannheimer Swartling in Singapore, who will navigate the gaps, I would say, with the disappearance of pre-existing investment protection regimes and what remains to be done to protect investors in this changing legal environment. So I first give the floor to Lucia. Thank you very much.
You have a full screen.
Yeah.
Yeah, now it's yeah. Working out. Seems to be in it. But somehow on full screen here. Oh no.
No, it's not.
You can start and now.
But you should go to slideshow. Slideshow.
Give ladies.
Yes, that's good.
Thanks. Thank you, Nicola, for your kind introduction. And I would also like to take this opportunity to thank BIFO and in particular Professor Jarek Krivoy for the invitation. It is a great honor and privilege to be in such fantastic company and to be able to discuss climate justice and the environmental, social, and governance standards with you. So let me dive in right into my topic. There can be no doubt that the global transition to a greener economy has become a priority for the states and the investors alike. I'm afraid I have some more statistics for you. It has been estimated by the IPCC, the Intergovernmental Panel on Climate Change, that $2.4 trillion will have to be invested in global energy systems until 2035 in order to limit global warming to 1.5 degrees Celsius. This represents about 2.5 of the global GDP. Given the magnitude, it is generally accepted that the governments of the world will need to rely on the private sector to finance the transition to greener economies. This is likely to lead to increasing the tension between the public interest nature of climate stability and commercial interests on the other hand, and therefore new disputes between investors and states are likely to arise. During the 15 or so minutes that I have today, I will discuss 3 key elements of climate justice. First, I will address the conflict between public interest and commercial interest and whether it can be reconciled. In second place, I will then move on to discussing climate justice in action, and will analyze trends from existing investor-state arbitrations that are related to climate change specifically. And finally, I will look at a possible new frontier of climate justice, and will try to predict where climate change-related disputes between the states and investors are headed. First things first, to talk about climate justice, we must confront the tension between the public interest in green economy transition and the commercial interests of private investors who have either invested in existing infrastructure or who are financing the transition to green economy. If you look at this from the perspective of international law, this translates as a conflict between existing environmental law obligations, between existing investment law obligations and the new arising environmental law obligations. This is because there are more than 3,000 bilateral and multilateral investment treaties that states have concluded to provide varying levels of protection to foreign investors. It is the commitment of the states to foreign investors under those VITs that might sometimes clash with their environmental obligations under more recent environmental and climate change treaties, such as the Paris Agreement, which is the best example, really. In addition, many claims brought by foreign investors tend to be in extractive industries and energy construction or water projects. This offers a fertile ground for a crossover between investment protection and obligations under environmental and climate change law. The states are very much aware of this conflict, as reflected in the recent treaty reform practice and case law. As far as the treaty reform goes, over the past few years, states have been introducing novel provisions in their BITs and trade agreements that enhance sustainable development, introduce carve-outs, and limit the scope of certain substantive protections. Notable examples include the United States, Mexico, and Canada agreement, which is the USMCA that replaced NAFTA, and also the Morocco and Nigeria BIT. As far as the recent case law goes, this is a topic that I will discuss in the second part of my presentation, when I will address how recent tribunals dealt with this conflict of norms and what notable trends there are. It is difficult to analyze climate change-related investor-state disputes because there is only a very small number of cases that can be characterized as having a link to climate change. The LSE's Grantham Research Institute on Climate Change and the Environment and Columbia Law School's Sabin Center for Climate Change Law, which are both leading world's research institutes that focus on climate change law, policy, and theory, have identified only 13 investor-state arbitrations where climate change policy, law, or science is at the center of the case. You can see the full list of all these 13 cases on the slide now. So after reviewing these cases, there are 4 key trends that I would like to share with you now. The first trend is that we can divide these disputes into 2 broad categories based on the context in which they arise. The first category includes cases where the investors claim that new measures introduced by the states to protect the environment have harmed the value of their investment. These are the cases written in red text on the screen and include cases brought by Uniper and RWE against Netherlands following its decision to phase out coal energy by 2030, which Matthew already alluded to earlier. Interestingly, Uniper was actually discontinued last month, so RWE is the one case pending. The second category includes cases where investors claim that a state's withdrawal of pre-existing measures to protect the environment have harmed the value of their investments. This argument has been raised in the renewable energy saga cases, which have been mentioned already earlier as well. And those are the cases brought against Spain or Italy following their withdrawal of government incentives promoting investments in wind power and solar energy. Again, these are the cases in red on the screen. There is a potential third category that can be identified mostly in the environmental protection sphere, where investors could claim that a state's failure to enforce national or international environmental laws has damaged their investment. This argument has been raised by the claimant in the Allard and Barbados arbitration, which concerned an investment in ecotourism sanctuary in Barbados. Mr. Allard alleged that Barbados caused environmental damage to his sanctuary and a loss of value to his investment in violation of the full protection and security standards. His claim ultimately failed. However, the tribunal did acknowledge that consideration of a host state's international obligations may be relevant when analyzing the application of the standard of full protection and security. This line of reasoning could be used in the future to argue that a state's failure to address climate change caused damage to foreign investments. Closely related to the first trend, which was the context in which the disputes arise, is the second trend, which is the fact that similar circumstances can lead to floodgate cases, increasing the risk of the state's exposure to higher damages. This has been the case again with the Netherlands' decision to phase out coal energy, which led to 2 cases, and also Spain's and Italy energy reforms, which has led to multiple cases based on the same fact, which I and other panelists have mentioned before. These again are set out in red on the screen. A third trend is a clear prevalence of the Energy Charter Treaty as a key instrument on which the investors rely in bringing these climate change related disputes against the state. Out of all cases, it has been the basis of 10 different claims. The ECT is an area of expertise of my co-panelist, Dr. Alejandro Carballo-Leida, so I will leave it to him to discuss it in more detail. And a final fourth trend is that the legal issues underlying these cases are controversial, and tribunals are not always aligned on how to best approach them. 10 cases out of all 13 have been decided already, and in over half of those cases, which corresponds to the 6 cases highlighted in yellow, 1 or sometimes 2 arbitrators have issued dissenting opinions. This exceeds the global average by a large margin. According to Jus Mundi, there have been 164 investment arbitration cases with dissenting opinions, which corresponds to 1 in every 5. Here we have 6 in 10. Eco-Oro and Colombia is a good example that illustrates challenges that arbitrators face in climate change related disputes. The case concerned Colombia's withdrawal of Eco-Oro's mining concession on environmental grounds. The majority sided with Eco-Oro and found that Colombia had failed to treat Eco-Oro in accordance with the minimum standard of treatment. However, Horacio Griguera Naon and Professor Philip Sands KC both issued dissenting opinions. Horacio Griguera Naon disagreed with the tribunal's dismissal of Eco-Oro's indirect expropriation claim. He found that Colombia's retroactive delimitation of the Paramo ecosystem was not done in good faith, and as a result, it substantially deprives Eco-Oro of its investments without offering adequate compensation. Professor Sands KC, on the other hand, found no breach of Colombia and Canada FTA. He acknowledged that there were problems in which the government handled the situation, and in particular, the delimiting of the Paramo ecosystem. But ultimately, there was no doubt that government's actions were motivated by the objective of environmental protection. He also pointed out that Eco-Oro knew or should have known that the protections in the affected Paramo ecosystem area were likely to become more restrictive. And before I move to my final part of the presentation, I would like to point you to Professor Sands' take on the inherently difficult nature of the climate change related disputes. Professor Sands says, I quote, that in the age of climate change and significant loss of biological diversity, it is clear that society finds itself in a state of transition. The law, including international law, must take account of that state of transition, which gives rise to numerous uncertainties. Adjudicators, judges, and arbitrators recognize the need to proceed with caution at a time of transition and uncertainty. Indeed, the precautionary principle has been developed to assist in the taking of decisions in times of uncertainty. As Professor Sen suggests, international law does have instruments to find balance in the conflict between obligations that states have to foreign investors and their climate change obligations. However, let's turn the tables for a moment and let's consider the investor's position in this equation. When it comes to the future of climate justice investment disputes, there is an argument to be made that environmental and climate change obligations are obligations that lie not only on the states, but also on the investors. Most of the existing BITs do not impose any obligations on the investors, and there is a growing concern about this perceived imbalance. A new wave of treaties has started to emerge, which provides express obligations on the investors to comply with the ESG standards and laws. The Morocco-Nigeria BIT or the Pan-African Investment Codes are notable examples. However, this idea does have some support in case law as well. This is the case, notably, of the tribunal's decision in Aven and Costa Rica, which concerns Costa Rica's revocation of an environmental viability permit and the termination of the investor's construction project in Las Olas. Mr. Aven commenced an exit arbitration against Costa Rica, who brought a counterclaim against him, alleging that the undertaken works adversely impacted the project site and caused damage to the environment. The tribunal accepted jurisdiction over the counterclaim, but dismissed it on the merits. However, in doing so, it made a number of important observations. It found that investors had an obligation under domestic law and under the applicable BIT to comply with environmental law and obligations. It went even further and found that investors could become subjects of international law, and as such, they had to comply with obligations which arise under international environmental law. While cases like Aven and Costa Rica are fact-specific and can be distinguished on that basis, the tribunal's reasoning in that case could have significant consequences for the climate justice and climate justice-related disputes. It has a potential to redefine investors' legitimate expectations, the police powers doctrine, and the scope of the FET standards. As a result, it can ultimately lead to shifting the balance between climate change obligations and obligations to investors and bring greater predictability to future disputes. Only time will tell if the reasoning in Aven and Costa Rica and the likes will prove to be the prevailing view. Thank you.
Thank you very much, Lucia, for this very clear and interesting presentation. Alejandro, you have the floor.
After this technical break, everything seems to be working well. Let me address how the tensions you just heard now from Lucia and from other speakers have been addressed. Some will say not completely addressed. Others have said well addressed in the reform of the ECT. The title was a bit tricky because it refers to the challenges, and I'm not going to focus on what seems to be the most evident challenges. I mean, really think about it. 55 contracting parties coming from Europe, Japan, Turkey, Jordan, Yemen, Ukraine, discussing simultaneously in English and in Russian, a multilateral agreement. So we're not talking only about investment protection standards to align them with the recent trends. We're talking about transit of energy, security issues, energy in general. I mean, that takes a lot of expertise mixed in the same room. But wait, hold on, there is no room. COVID just strike at the beginning of the discussions. We have to move online. And again, online, how do you move online? When you have government restrictions to Zoom, no way you can use Zoom or these other platforms. So you have to find all these technicalities to move into the capacity building for officials to be used to actually navigate all those presentations, explanations, but more important, even that, how they coordinate themselves. I mean, how the EU member states coordinate among themselves to say this is what we want to say in the middle of the negotiations when everybody is in their own room or house or whatever in the hotel they got lost. How do you coordinate a coffee break to kind of soften some of the problems that arise in a particular issue on perhaps security? You have to coordinate these small chat rooms online, etc. And then, well, perhaps still too easy. We have Ukraine invasion. We have conflict between two cooperating parties ongoing. Well, I'm not going to talk too much about that. That seems to be the easy part of the challenges. What I'm going to focus is what were the main challenges if you look at the substance of the discussions. And again, this is my opinion. Delegates may have a different opinion, and external people may have a different opinion about it. I will say investment protection standards. No way. That was not the main difficult part of all the discussion. Yes, we have challenging discussions about FET, where, well, you are aware FET in the ECT, it just says FET. That's it. We have case law, more or less going in somewhere, but suddenly you saw the result in principle when we said, well, let's put some borders in the FET. What means really when it is triggered, legitimate expectations, mainly because all those main cases already referred before. But those are not the triggering factors in more challenging discussions. It was actually how to deal with those challenges that just mentioned before. How to deal with this energy transition. It's not that there is nothing in the current ECT. We have a preamble reference to the UNFCCC. We have Article 19 on environmental issues saying, well, you have to minimize the harm to the environment. And you have taken into account your own obligations under investment and environmental agreements. But if you look at the case law, well, not really tested. Not many cases, if you look at ECT cases, you will find references on either side to environment, energy transition, climate, anything like that. The reason may well be that actually, if you look at the case law statistics, and you have a very interesting website, energychartertreaty.org, publicity here, where you can find a lot of statistics, cases, organizations who are involved, arbitrators, and you will find that 76% of the cases under the ECT against EU member states or the EU refer to renewable energy, which is an instrument for energy transition. So of course, not much discussion is going to be there about energy transition or climate change, because it's about actually renewable energy. The same if you look at the broad picture. Okay? It's around 60 something. Now, if you look about how many cases on climate change in particular, we may have disagreements here. I've seen all sorts of statistics and numbers, reference to Vattenfall being energy transition, when I don't think that's about energy transition, it's a different thing. You look carefully and you can find a couple of cases, some of which have been discontinued already. So there is not much there that you can see how the current ECT is really useful or not useful for those particular cases. It is still to be tested, but certainly more cases will come in the future. And that's one of the reasons where one of the topics for discussion was how we will go to deal with that one. And that's why you have on the screen a news item we published to clarify what was achieved in this agreement in principle and how this alignment with Paris Agreement, we thought it was reached. But actually, wait a minute, not we thought. The European Commission in October 2022 said, and I quote, amendments will bring effectively the ECT in line, not only with investment standards, which is fine, but also with the energy and climate objectives of the European Union, including the Paris Agreement. So delegations thought, well, taking into account what we have here and who is involved, you need to reach a middle point, and well, something was achieved here. Actually, even the European Parliament resolution, at some point, also welcomes and confirms some of the reforms achieved in these negotiations. Even if at the end it says, yes, but, you know, it doesn't really align with the Paris Agreement. I'm not going to tell you how or why, you'll find out. But it's true that you have several things there that are fitting quite well. And what are those things? I will just mention some of them, but you have in the news items, and I can give you more information later if you want to. You see there is a double column. I will not enter into more details, just to say the structure tries to follow what were the ideas presented by UNCTAD on what could be climate change related provisions. And for that, I will let our colleague from UNCTAD to explain later all those provisions. It's a great work. UNCTAD is always very helpful on these discussions, and we try to support and follow as much as possible. So we try to find out, okay, what they are proposing and where are we? And we saw, well, in most of things, we are ticking that. You know, maybe there are two options, we have one of them, but we in general more or less follow what is proposed. Well, preamble, yes, of course, easy. Preamble, no obligations there, perhaps. We have more wording on what? Not only about the UNFCCC that already exists, but also their right to regulate in the interest of legitimate policy objections. But more important, the scope of the treaty. What are we going to protect in the future? And that was the main discussion. It took a long time and different opinions and different level of exchanges. Yeah, very passionate sometimes. And what was the result of this? The result of this was to introduce a so-called flexibility mechanism. And we say, what does the Paris Agreement say? Does it say, as of tomorrow, we stop fossil fuels? No, it doesn't say that. It says, we are different. We have different needs, different circumstances, different security issues. We all want to achieve this, but we may go through different paths at a different pace and timings. And that's what we said, okay, this is what we are going to take into account. We don't require Kazakhstan or whoever, Yemen, to follow the same timing as the European Union. We say, you are adults and you are the ones who have committed, and you are the ones who can say, what is your timing and how do you want to achieve this? So we are giving you the tool for doing that. We are giving you the tool to say, when do you want to exclude and what kind of fossil fuel investments you want to exclude the protection? Okay, taking into account what's your energy security and climate goals. And in that case, for the UK, for the EU, is okay, for existing ones, 10 years with different conditions, whether it's gas or transit, etc. Of course, all this with the possibility of reciprocity. So if the EU doesn't protect investments in fossil fuels of, I don't know, Uzbek investor, so Uzbekistan can say, I do the same thing, so I'm not going to protect your EU investments in fossil fuels in my country. But it's a reciprocity that has to be expressly requested by the host country, otherwise it will be protected. Second thing, well, it's more important that we try to still coordinate and to align things. So every 5 years, we are going to sit down again and we are going to revise all this. And we are not going to say, okay, the EU proposed this, the UK is applying this, but we are going to say, can we all agree on something we need to phase out? Can we all agree on something we need to still cover because there are new energy materials, new energy projects that will need to be covered? So every 5 years, let's sit down and revise something that will apply to everyone, not only to the UK or to the EU. And even more important, perhaps, it was a specific date as of which no new investments in fossil fuels will be protected in the European Union or in the UK. Now, sorry for that. That's all news, 15th of August. I think you're all aware there are a bit of delays on the adoption and discussion. So probably that 15th of August is not going to be anymore, and it's going to be a bit of a change there. But that was the idea. So no new investments protected after some period of time. And the important thing is that whereas the flexibility mechanism requires some ratification and discussion, this is a change in the annexes, so will apply immediately, indirectly for everyone at all point in time. And then you have, I'm not going to extend too much, but you can find it there, references to investor obligations, a specific provision on the Paris Agreement and the commitments on the Latin parties on that Paris Agreement and ILO fundamental conventions and all environmental agreements. The first time with a particular transparency and dispute settlement mechanism and particular regulations on the right to regulate being allowed for climate change and express a statement that when there are non-discriminatory measures to protect legitimate policy objectives, including climate change, there will not be indirect expropriation. Taking into account the time is running, I will stop. Oh no, it's fine. Okay, we still have 2 minutes. Okay, so there are several places where there is a reference to the right to regulate, but there is a particular provision on the right to regulate. There is this particular mention how this is to be dealt, in which cases, with particular references, including indirect expropriation, what I mentioned before. And there is even a reaffirmation of the Latin parties to commit to clean energy transition and to promote low carbon technology. So there are a lot of elements there saying, well, perhaps the current version of the treaty doesn't give you all the tools, but I think with all this, you have a lot of materials to say, well, you have arguments to deal with this energy transition in the future. Of course, all those things will have to be tested. There are not many agreements you can find out there to compare and say, well, you really did a good job and tick everything that was needed there. No, on the contrary, it was a good first exercise to try to see how to put all those things together in a very multilateral exercise, so not just a bilateral exercise between two contracting parties, and a multilateral exercise that actually also covers all sorts of different energy security requirements and circumstances and conditions. We are still hoping that this will go forward and there will be an adoption, and ACT, of course, will continue. Different thing will be, of course, how many contracting parties will remain, how many contracting parties may join later in the future, perhaps. So with that there, I think for further questions if needed, I think we can now give the floor to the little experts.
Many thanks, Alejandro. Very inspiring, motivated. We can see that you're still a believer, and it does impress the audience. So now we can move to the third presentation. Jacob, please, you have the floor. Thank you.
I will stand up for my presentation. Good morning and perhaps early good afternoon to everyone, depending on where you are. Because we have, of course, people calling in to this event as well. So the topic provided to me for today's conference is to speak about the ECT reform from an arbitration lawyer's perspective. And as an arbitration lawyer, one, of course, can adopt very different perspectives on this issue, including the announced withdrawal of certain countries from the ECT, and the ambition of the EU to do away with the sunset clause and so forth. My colleagues on the panel have already discussed some of these issues. Some of these issues were also actually addressed earlier this morning. So I will therefore try to offer a somewhat different perspective on the proposed reforms and the latest developments. Because in view of the challenges and difficulties facing the ECT, as we all know, and the uncertainties as to what will happen going forward, I believe that we as arbitration lawyers will start taking a fresh look at other options, and one being bilateral investment treaties. And I'm now talking about the BITs that exist within the territory, so to speak, of the ECT. And this will be then alongside the protection provided, for example, by foreign investment laws in certain countries, and we have private agreements, concession agreements that were alluded to this morning. So at the time of my disposal, I will give you an overview of the investment protection that foreign investors in the energy sector have, irrespective of what will be the end result of the reform and the modernization, if any, of the ECT. I think as a starting point, I think it's fair to say that many of us arbitration lawyers have looked upon the ECT, at least in its current form, as some form of holy grail when we are representing foreign investors. Because it normally, and I think perhaps in general, provides relatively good protection for foreign investors in the energy sector, both in terms of jurisdiction, substantive protection standards, and dispute settlement. The ECT provides a very favorable, relatively speaking, protection for investors. And I think it's also fair to say that relatively few investors, when given the choice between the ECT and a potential BIT, would choose to submit a claim under a BIT. And I think that's what we've seen in practice. Now, of course, we may have the sunset clause still being applicable, but it's very much up in the air at the moment. And I'm not only speaking about the intra-EU context, I'm also speaking about the extra-EU, as I think Matthew alluded to earlier this morning. Yes, legally speaking, the sunset clause should be there, but who knows what's going to happen. So to help to illustrate the existing BIT protection between ECT contracting parties, I've put together a few maps, a few spider web maps, and I've used data provided by UNCTAD, the UNCTAD's investment policy hub, to create these maps. And this is the first one. I should say that the maps include BITs that are in force, but also BITs that are signed, but not yet in force. But the latter category is relatively small. It doesn't really track from the general impression. So the first map you see here on the screen shows the many BITs that exist between the various contracting states to the ECT. I have on this map excluded intra-EU BITs. But apart from those, all BITs concluded in between ECT contracting states are included. So that, of course, that includes not only BITs concluded between an EU member state and the non-EU member states, but also BITs concluded between ECT contracting parties that are both not members of the European Union. And as you can see, the result is very difficult to digest in any detail, and that's not the point. The main takeaway here is to convey the message that there is quite a lot of protection out there, irrespective of the ECT. And the number of BITs that are being indicated on this map are 484. So we have almost 500 BITs within this particular ECT territory. A similar picture emerges if we only look at BITs included between, on the one hand, an EU member state and a non-EU member state within the territory of the ECT. Here we have 342 BITs, and the general impression remains the same, that there's still a lot of protection available. And the third map, and this is once again by illustration, mainly, if we look at countries that are contracting parties to the ECT, but not members of the European Union, we have 142 BITs concluded between these countries, according to UNCTAD. So still quite significant. Now, in order for this presentation to become a little bit more specific, I thought it could be useful to look more closely at the BIT protection afforded in relation to a specific country. I thought I'd use actually Turkey as an example to tie this in with the previous panel. I know that this was perhaps a little bit too audacious for me, but nevertheless, and of course, Dr. Sarah, please correct me if I'm wrong in anything that I will say. And I also chose Turkey because I understand that Turkey is in the midst of a relatively large transition into green energy. And that if you look at the European Investment Bank statistics, there is a lot of investments from EU countries being funded by the IB going into Turkey. So the question is, apart from the ECT, what kind of protection does Turkey offer to foreign investors? Here again, I used the UNCTAD investment policy hub, and they have a particular function for mapped treaty elements. So it is possible to provide an overview of certain elements of such protection by using this particular function. I should say that there will be no slides for this part of the presentation because I wanted to listen to Dr. Sarah before I chose what to say. So we can begin with some basic figures, which I think in and of themselves are quite interesting. That Turkey is party to 48 BITs with other ECT member states. Half of them are with EU member states, and half of them are with non-EU member states. And as regards to BITs with EU member states, the only 3 countries that are missing here are Cyprus, Ireland, and Malta. Apart from that, Turkey is covered quite well in relationship with EU member states. If we then look at the protection that Turkey's BITs offer within the territory of the ECT, and once again, very, very briefly and generally, all 39 BITs that are mapped by UNCTAD's mapped element function provides that there is an asset-based definition of investments in these BITs, which normally provides a relatively low threshold, I would say, for foreign investors to meet. Of course, we know that if a tribunal would like to apply the Salini criteria or something similar, there may be more restrictions in terms of what kind of investments are protected. And of course, we have seen that in the proposed modernized ECT, there are a proposal to include Salini-like criteria. And then this is something that maybe had also in relation to the application of these protection standards. If we then continue to the denial of benefits clause, which is another element that I think Matthew mentioned this morning, and which has received some attention in recent times because Germany declared in March of this year that it will invoke that particular clause of the ECT in relation to investments owned by Russian nationals. You can see that in Turkish BITs, only 2 of Turkish BITs contain such a provision. Then very briefly, when it comes to investment protection standards, all Turkish BITs contain an expropriation provision for protection against expropriation. They all contain an MFN clause. All but 2 have a national treatment clause. So I think that's very standard and very positive for foreign investors. What I found a little bit more surprising when I looked at this was that quite a few of the treaties do not contain a protection for fair and equitable treatment. 1/3 of these BITs do not contain an FET provision. And about half of them do not contain any protection against unreasonable, discriminatory, or arbitrary measures. And then if we wrap up with dispute resolution provisions, you have exit arbitration across the board, basically with UNCTAD or domestic ports as alternatives. So this was just an example. So in conclusion, I would like to take you back to the three maps that I showed earlier, and just to convey the message once again that yes, we have challenges and difficulties with ECT. We don't really know what's going to happen. But the picture that emerges from the review of the BITs within the ECT territory is that there could still be protection out there for investors. And yes, depending on the state concerned and the nationality of the foreign investor, it may be that there will be no protection, or the protection will be less than under the ECT. But in many instances, protection will be available. Thank you very much.
Thank you very much, Jacob. So now we have quite some time left for a discussion and questions. Let me first perhaps stop my timer, since
We can finish a bit earlier as well. I was told that the lunch would be ready in about 20 minutes if we have to go.
we take 20 minutes for the...
It can be either 20 minutes, or if the discussions are lively, we can stay.
Okay, good. Now, shall we start the first round? I don't want to organize the discussion more than necessary. Perhaps I will do that at a later stage as we evolve, but perhaps just a free round of questions. Yarik.
Okay, yeah, I'll ask the first question. I will have two more. To Alejandro, the same I asked Matthew. So what would be the legal way to avoid the sunset clause if you can't reach an agreement between all member states? Is there a legal way or not? That's my question.
Christoph Bont again. Actually, I had a comment. It's more of a comment from Lucia about some of the language that you used, which I think illustrates one of the challenges in trying to analyze these cases. You were just distinguishing between cases where investors claim new measures introduced have harmed the value of their investment, and claims where state withdraws existing measures have harmed the value of their investment. My problem with that is that's not what they're claiming. They're not claiming that you have harmed the value of my investment as the basis for their claim. For example, in Lone Pine, they're claiming that the measure that was adopted was arbitrary or discriminatory. They're not, in the Spanish cases, they were claiming that the measures that were adopted were in violation of the legitimate expectations, by and large. So the issue that I have is with the kind of framing of the cases, because at the end of the day, as lawyers, it's about the application of legal standards. And I think one of the problems in the larger discussion about investor state cases is that it's framed in The Guardian and other places as it's every time the state makes a change to a regulatory that has an impact on the profitability of the investment, you have a claim, which is absolute rubbish. It's about the standards. And so I wonder really if that shouldn't be the focus of an analysis.
Sorry, hi, Eliane from Evershed Sutherland. Thank you all for your presentations. Sorry, I'm quite far back. My question is actually for Lucia as well. Lucia, at the end of your presentation, you quite interested at investors' environmental obligations. And I was wondering how you would see that in tomorrow's world, as Matthew put it in the first session, how that would bite in terms of, can you see, for instance, ISDS being used by states who are normally on the defensive? Could they, for instance, start going on the offensive in some form by utilizing these obligations either as a defense or, you know, going after the investor as well?
Okay.
I guess I will go first. So the first thing I could mention is that you may have seen the still publicly available short summaries after each round of negotiations. And you may have noticed no discussion about sunset clause. That only comes at the very last minute after there's an agreement in principle and further developments appear. But for the time being, during the 2 years negotiations, nobody raised an issue on that particular topic. Second thing, we only have, you have heard some discussion on a proposal on a potential removal of sunset clause, but it's a partial one. It's only for non-application intra-EU. So sunset clause in DCT is partial already because it only refers to investment protection. It excludes transit obligations and other things, trade, and so it's already partial. And the EU proposal or the initial EU proposed is already more partial because it only refers to the intra-EU. Now the question that was raised is what will happen with other contracting parties. Of course, we understand that any such an agreement would require the agreement of all the contracting parties involved. That's the first thing. You have posted a letter reply of the Secretary General to some of the concerns about that proposal, already partial or limited, for removing the sunset clause, and what could be the limitations in the international law, starting from the point that the potential understanding or interpretation of no intra-EU that is expressly contained in the possible modified ECT, if it's not adopted, well, it's not already there. There are some contracting parties may already have left the ECT before they reach any agreement, but that's just for the EU proposed one. When you again go and say, well, but actually what I'm interested in seeing is whether that can apply for, I don't know, an EU investor in Japan or Kazakhstan. Well, that my understanding is that, of course, it will require some agreement between all contracting parties involved. And for the time being, as you are aware, I'm not aware of any such a discussion.
Thank you. Perhaps if I may make a small comment on the ECT process, as an observer, I find it somewhat disturbing that we don't have the text. And the reason for this is that I keep telling governmental negotiators to make sure that your text is appropriate. You must submit it to litigators. It must be litigators proof, because litigators read legal texts differently from the diplomats who negotiate them. And so I think that it is necessary to build confidence that the text be made available, that we can check whether the objectives that are set to be achieved by the modernization process will indeed resist the scrutiny of us all, right? Thank you.
Thank you for the first question. Apologies then about the language which I used. It was my intention to focus on the investors' claims of harm per se, but it was more to try to show the different contexts in which those disrespects arise, and to make a distinction between the fact that one of the categories is where there are new environmental measures, which then leads to claims. The second category was when there were environmental protections or certain standards and concessions based on environmental principles which were removed, which is the Spanish saga. And then the third speculative category being the state's failure to comply with the environmental laws. But I take the point on board that one has to be careful with the language. So thank you for pointing it out. However, you raised another issue, which is the standards, the protection standards, which are applicable, and that should be the focus of the debates. And I wholeheartedly agree. And if we actually look at those cases which I discussed and the breaches, for example, which were found, there is a clear trend for the FET. So I think from memory now, there were 10 decided cases. 6 were decided in favor of the investors and 4 in favor of the states. And out of those cases decided of the investors. In all but one, there was a breach of the FET, or the minimum standard of treatment, since it's the Energy Charter Treaty. standard which applies, which was found, and there was only one case of indirect expropriation, which is the Rockhopper and Italy dispute, which was found. So I think that's an interesting illustration of where those standards of protection go in this context and how they are found. And once the investors manage to get through the jurisdiction hurdles, they tend to be relatively successful in this context so far, and mostly that's on the basis of the state treating them unfairly. That's.
Yeah, I think it shows that it's less about.
Let's use the mic.
I think that shows exactly that it's less about a conflict of norms between, say, environmental protection and investment and kind of investor right to profit, so to speak, but rather about issues of fundamental fairness in the treatment of those investors in the introduction of withdrawal. So those are the standards which, as you're pointing out, are effective. If I can mention too, I was counsel in the Allard matter, and what was interesting again was it was about the facts. It was about the fact that the investor was alleging that Barbados, for whom I was counsel, wasn't protecting the environment sufficiently, but really, from the perspective of Barbados, they were trying to pursue a scientific investigation of the site and to know what needed to be done. And he just wasn't very happy with that from his own personal perspective and the kind of way it was being done. So my long impression from these cases is it always matters about the facts. Although I take your point that it's interesting that a principle was introduced in that discussion.
Absolutely does. And maybe in Allard and Barbados, and you're going to be able to correct me if I'm wrong, but I think one of the things which the tribunal said even was that the tribunal doesn't have the right to choose how he wants to be protected or how the state applies those protections. It is sufficient that the state does. And in this case, the fact that Allard wanted the protections to be applied differently didn't quite come up to a breach of protection. So. Yeah,
and a crucial part of the evidence in that case was we presented evidence from the government scientists to show that they were seeking to pursue in good faith a proper environmental solution for that site.
Thank you. Thank you for that. And then if I made the second question, which was about the flipping perspectives and what would happen if the states went to defensive. We're going to have to wait and see what happens, I think, is the easy answer or the kind of, the cheeky answer to that. But in terms of what's happening in the treaty reform and and the cases, increasingly the new treaties, and here I don't want to go to the territory of the third panel, which is going to be addressing treaty reform in more details, but there are increasing provisions which provide express rights for the states to regulate, which provide express obligations on the investors. And if these come to play, we could maybe see the fact that if the investor themselves didn't comply with either domestic or international environmental obligations, it could potentially pose challenges to admissibility. I believe this is an open question, if that could be used as a potential mechanism. We could also see a situation where the tribunal would find a breach, but award no damages. And there was at least one case in those 13, but I will have to look up which one it was, where a breach was found, but no damages were awarded. So that's also a symbolic way of saying, well, okay, maybe there was a breach, but because the investor didn't really comply with their obligations, it doesn't entitle them to get damages. And final thought, which I wanted to leave with you just for a moment, but that's a topic in itself, which could be addressed by a panel, is counterclaims. And increasingly, some of the new treaties or model BITs that are being concluded these days do include some provisions that do provide for counterclaims. And that was, in the end of the day, what had been alleged in the Aven and Costa Rica. And I think there is only one successful counterclaim, which came from the Burlington case. But nonetheless, a question remains open as to whether, if there is a proper legal instrument that gives grounds to consent of the investor, because as we know, consent is the key issue, could we see a future where more counterclaims by the states are a reality?
Thank you. Further questions? So.
Thank you. Mustafa Mertecile, Queen Mary University of London, and also Energy Disputes Arbitration Center. So you gave Turkey as an example and a very insightful analysis. So my question is, did you have the chance to look into the dispute resolution clauses of the mentioned BITs or the arbitration culture of the country in general? Any thoughts or evaluations on that?
Or perhaps one more, second round of 3 questions.
It's also for Alejandro. We hear quite a lot about what the EU wants from the ECT process, but I haven't heard much about, let's say, what Kyrgyzstan wants or Kazakhstan or some other countries. Is there any trend which you can identify? I heard that Japan is happy with what there is already, but maybe it's also wrong.
Okay, sure. Alan Riley, Energy Community. My observation in relation to the ECT is I've been doing a lot of work on kind of energy security issues and more kind of short-term questions. And one of the kind of observations which I see actually in the market at the moment is that at one level, the EU is talking about obviously focusing on renewables, climate change issues, but at the same time, there's enormous policy pressure to deal with the energy security issues. I mean, we have a situation where we were very lucky this winter. We may have a problem for the next 3 or 4 winters. We're going to have to replace enormous amounts of Russian gas for the foreseeable future. Renewables, at the end of the day, will at least need backup from fossil fuels for a very long time to come. And actually, we're going to need more fossil fuel investment. I mean, this is kind of not heresy exactly. It is also partly Commission energy security policy. And this seems to me to be, this is a policy as much as a legal question, perhaps, but more a policy question. But there is actually almost a contradiction between some of the positions the Commission is taking in relation to the energy community, the Energy Charter Treaty, and the actual policy position the Commission is taking in relation to energy security. On that basis, it would appear to be that it would be very difficult to organize additional production of fossil fuels, particularly gas, anywhere within the territory of the European Union. However, we were short about 75 billion cubic meters last year. This year, we're going to be 100 billion cubic meters short. And we are going to be in a much more difficult position in many ways, and things could get much more difficult right through until the late 2020s. So that's my kind of general observation I would make on the ECT Commission diatribe.
Would you like to add something? Yes, please, first you, and then I'll come back.
So coming back to Turkey, yes, I looked at it briefly. I seem to recall that most of the arbitration agreements in these treaties refer to ICSID. So that's the sort of the general preference, it would seem. And then there are alternatives, normally alternatives to that for the investor to choose, UNCITRAL being one, and actually domestic courts being mentioned in some instances. So I think that's the general picture.
Yeah, so I think it's my turn. So to the first question, it's interesting because when you read many articles about the modernization of the ECTs, or the EU promoted, the EU put it forward, and well, actually, all this discussion started in somewhere around 2017 with an intention, let's revise, have a look about these investment protection standards. And are they applied correctly in a coherent way, looking at the case law? And at some point, we had a meeting with experts. There were some conclusions saying, well, in general terms, not bad, not bad. You can do something else, but not bad. But still, it was interesting. Let's go farther with that one. Let's not look just about how they are applied, but let's look about the new trends. Are they, compatible with what we have? Are we out of line? And then at that point in time, some contracting parties, and not the European Union and the member states, said, well, if we have to go and revise more in deep detail provisions of the ECT, may we remind this is not an investment agreement, it's a trade and transit and energy security. So if we look into a small part of it, even if it's very well known and used, maybe we have to revise the whole thing because, it's an exercise of balance of all the provisions there. As I just mentioned, it's not just about protecting investment, but also about energy security. You protect investments in the energy, but if the energy cannot flow around and you're not securing that energy transit, to some point, you are missing something there. So the whole thing was said to be revised, all the provisions, and this came not from the European Union, but from other connecting parties. Of course, you cannot compare the interests of Yemen, well, Afghanistan right now, I cannot even tell you, the European Union and other contracting parties. For some, the transit issues are very important, and even more important about that the invest protection standards. For others, security is the key concept or really relevant. So each contracting party may have different understandings. All of them contributed, and that's clearly a very interesting point. I mean, it was not just a discussion between, I don't know, let's say European Union and Japan. I mean, you have UK, you have Azerbaijan, Armenia, you have Kazakhstan, you have Jordan. So there was really discussions there, Georgia. There were many involved in all these discussions. So it's not just a matter of, okay, this is what the EU wanted, is whether we have achieved what the EU wanted. It is something that was put on the table by all contracting parties. Most of them were deeply involved, putting proposals, suggestions, comments, their own experience in the case law. And the result, again, is something that could be considered as a balance that all of them could say, well, we can live with this. We understand that I cannot achieve 100% what I want, but it's something that could work for all of us. And that's the important thing. Okay. And at this point in time, well, you have seen the news, you have seen everything, you have seen who proposed postponement of the discussions. On the other hand, we look at the energy security. And as we mentioned before, this is really important when you look at the ECT. It's not just about protection, it's energy security. Where there is incoherence or inconsistency, well, that's for the EU and the member states to decide and to say what they want and want to achieve. It's nothing we can discuss about it. Clearly, that was one of the reasons why there was flexibility in the phasing out. It was not to say, guys, as of tomorrow you will wake up, no more protection. No, come on, this is not possible, and we all know. And at the time we are discussing this with the Ukraine invasion, we even know more about the situation. So we know there needs to be some timing, there should be some process. And that was the reason to provide different timings. Perhaps also something that is not much mentioned. I think you raised it in other places, but actually the ECT is part of other agreements of which the EU is party to. For example, if you take the EU-Ukraine, well, it contains an article saying transit of the ECT is expressly incorporated here. Okay, so what happens if you have a dispute on transit? The EU is not part of the ECT, but it's actually applying ECT Article 7 on transit with the obligations and even conciliation mechanism. We have, let's say, a new provider of gas, Azerbaijan. Oh, we have a cooperation agreement, EU-Azerbaijan. It also incorporates the ECT and says all this is taken into account the ECT and blah, blah, blah. So there are also references there. And I can tell you that for some connecting parties, energy security and security in general was an important element of the discussion. But of course, when you put that into the table, it would have to be taken into account in different ways. And just one small comment in relation also to Jacob's presentation. One interesting thing is, okay, let's say that there is a withdrawal from the EU member states because of fossil fuel protection of the ECT. The European Parliament says, inconsistent. You keep thousands of BIDs and all of them protect fossil fuels. CETA protects fossil fuels. So what are you going to do? Are you going to withdraw from those bilateral investment agreements? Then what he just mentioned, falls down because you don't have any investment agreement protecting, unless you renegotiate. I renegotiate thousands of them. Well, you try with ECT. Is it going to work? If not, if you don't have investment agreements, and then you may go back to what I has mentioned before. Well, you have to focus on diplomatic protection and on contracts. Is this what is expected to happen, or what? That's something that is silly to think about.
May I come to your rescue, Alejandro? When the EU was confronted with the fact that the investment chapters in its trade agreements were mixed agreements from the EU constitutional perspective, therefore needed the agreement of the member states, etc., it decided to extract the investment chapters from the trade agreements to move forward on what was within the exclusive competence of the EU. Would it make sense as a second best option from your perspective to extract the investment chapter from the modernized ECT so that it would be open to signature separately, and therefore you would not, in French we say, jeter le bébé avec l'eau de bain. You would not prevent the member states who are interested in the trade provisions, in the security provisions, from participating in the modernized ECT because they don't like the investment chapter.
I cannot reply on that one. It's up to the EU what they want to do or not, and how to address things. The only thing I can say, and you have in several editions of the conference, including the move to modernization, is that for many parties, this is a balanced agreement covering the whole energy sector. And that's why it makes it so interesting to this treaty, that it tries to cover anything that is relevant for the energy sector. It's not an investment agreement alone, of which you have many VITs or whatever.
Sure, but that has become the Achilles heel of the whole agreement. That's the point.
Right. See? So it's at the end of the day, it's up to the member states what they want to do. The only thing I can say is that for many of them, and it was quite clearly mentioned in the conference decision, is that this is a self-contained, a comprehensive agreement, and that's the relevance for many contracting parties.
Thank you very much. I think we have reached the deadline.
We can still have a few more
Do we have
minutes.
further questions? Okay, thank you. I apologize.
There are more questions.
Don't mean to monopolize the questions, but I am interested, Alejandro, following on that. Is the reason that the EU is pulling out or thinking about pulling out of the ECT now, announcing that member states, because of the environmental provisions and the issue of compatibility between the environment and, say, investment protection, or is it for other reasons?
The only thing I can say is what is publicly available. You have France and Germany notified withdrawal from the ECT in December last year. The argument is that it's not aligned enough with the Paris Agreement. You have Poland also notified in December last year with a different argument, saying we want to comply with EU law, and the current ECT does not allow us to comply with EU law because of the intra-EU. We raised the question of there is a new provision expressly stating about what will happen in intra-EU, but so you see that there is a different argument between Poland and Germany and France. For the rest, we don't know. We'll have to wait and see what are the concerns. What we have heard from some other EU contracting parties, you have seen it publicly available. Denmark recently made another statement. Spain, they generally refer to not ambitious enough. From our side, we thought it is something realistic, something that comply with what's put on the table by contracting parties, and something more or less in line with whatever it is there in the market. We didn't see any investment agreement more ambitious than this particular reform. But that's the argument that has been raised, and we are waiting to see.
Thank you so much. It was very interesting very interesting presentations and a very interesting discussion. Thank you to all.
And thank you, Nicolas, for moderating it. Lunch is already served downstairs. I think it's ready. So just go there and then left one level, and then you will find the place. And we'll be